on John's Briefs today, back with Terry Johnson from Firearms Legal Protection. About today, I want to talk about the Kyle Rittenhouse trial and how typical this trial was, and if what we saw on, as it was broadcast is what we should expect in our trial.
Firearms Legal Protection just started a 100% free monthly newsletter to bring quality, accurate information about legal self-defense to good, sane, sober, moral, prudent people like you. Go sign up for free, no-hassle help for your self-defense at the link in the description, and thank them for sponsoring today's lesson.
So, Terry, if I asked you that question, is this trial is this how trials go? What would be your answer?
It's probably more realistic than not what you saw. Unfortunately, when you put a camera in a courtroom, people have a tendency to believe that they are actors and they're trying for an academy and things along those lines. But yes, you will see people fighting like that in a courtroom, especially when it comes down to a self-defense case. I'll give you an example. Will attorneys play games? Unfortunately, yes. Unfortunately, yes. And it's not just one side, it's both sides. Because again, you're trying to get a leg up here, a leg up there, and you don't know the pressures that are on the other side. So for example, from the prosecution side, it may be mandated that, hey, we're not going to give a deal. We've got to get a guilty verdict, because if we don't do something, the elected prosecutor may not get reelected again.
Right.
This may send a wrong message to the community. There are many things that go on, but for the most part, what you saw is realistic. Even down to the judge, just really reprimanding the attorneys. That happens.
I want to talk about that because the judge, Bruce Schrader, he had read Thomas Binger, the riot act, in open court. I expected him to get a freaking newspaper out and hit him in the nose with it at some point, for gracious sakes. Literally in open court, he told him, back in Roman times, if somebody tried to pull that stunt, they would give him floor tickets to the Coliseum and feed him to the lions. And he literally said that to him in open court. So have you heard stuff like that while you were in trial, Terry?
Yeah, here's the thing, you have to manage the situation. If a judge were to say that to me, I would say, well, Judge, you've made your feelings very well known. I'm going to ask you to recuse yourself at this point, because I don't think my client can get a fair trial. I'm asking for a mistrial at this point. And the judge will look, oh, you're not going to get it, but I've made a record of it, right?
Right. Now you at least put it in there.
Right. And there comes a time when you have to listen. All of the attorneys are very, what's the word I want to use? Very respectful of the bench, the judges. But again, you have to be able to stand up and let the judge know, okay, I got a job to do. You've got a job to do. I'm not just going to lay down and let you run over me. Right. I have to put up a fight, and it's not being disrespectful. But again, in the case what we saw here, the interesting thing was this prosecutor, in my opinion, never fought back. He just said, oh, okay. And then he went on and did the same thing again. And the judge slapped him upside the head, and he did the same thing again.
Listen, I'm not going to, I will speculate. I don't have any inside baseball as to the ADA, Thomas Binger, who was the head of their prosecution, his motivations or what happened there. But this guy has argued a lot of cases in court, and he did a really poor job for the most part, like a ridiculously poor job. And I wonder if he really was giving his best effort here.
Well, I guess my question would be, why do you say he did a poor job? I heard that from a lot of people, but I don't necessarily. When Kyle Rittenhouse was on the stand, and I said this to a lot of people, I thought he gained lots of points in his cross-examination. And quite honestly, I didn't think Rittenhouse was as prepared as he should have been. And I thought that was to me, a point that I started to get a little worried.
I thought if anything, he was strong there. But even in calling his other witnesses, even in when the judge would just slap him upside the head, he didn't come back. And he just kind of sat there and took it like, oh, okay, I'm just going to sit here. Obviously, his legal case was poor. He didn't have a case in reality, full acquittal, right? So, and it just
But
felt to me sitting watching him there like he knew he didn't have a case that he could get a conviction on.
well, but think about this. If it was that weak, why was the jury out so long?
All right, that's fair.
And
Uh,
and the other part of that is, you never know. You think you know what a witness is going to say when they take the stand. I have seen witnesses come up and they have testified to things that we've never heard before. And it's like, oh, what do I, and you sit in the back of your mind, you're like, what do I do now? What do I take this? What do I do? That's not what we just talked about. Um, there, that's where you try and rehabilitate them at some point, on redirect or recross or what have you. But I, I don't think he did as poor of a job as you think he did.
okay, well, I
Just
mean, you've
from,
got a lot more experience here.
but I just think his case was not as strong as it could have been.
It was definitely well, and given the evidence there, I don't, I think that the evidence that was presented, the jury got the right verdict. The other thing that I
Absolutely.
think is it typical or not typical was there's no requirement for the defendant to take the stand in a criminal trial, and yet they chose to have Kyle Rittenhouse come to the stand in self-defense cases. Is that typical?
Well, here's the thing, and you got to be very careful. And I want people to understand, if you want the jury instruction, like the one that Kyle Rittenhouse got, that basically said, he was acting in self-defense, you pretty much have to take the stand, unless there's some extenuating um, evidence out there that comes in another manner. So, I had a case where a guy was on video telling someone, I will defend myself if you come forward. If you come any closer, I'll defend myself. So I didn't have to put that guy on the stand because his state of mind was already present. And I asked for the instruction, was able to get it. In this case, no one knew what was in Kyle Rittenhouse's mind.
Right.
Okay. So, yes, if you want, I'd say 95% of the time, barring extenuating circumstances, if you want that instruction to the jury that this is self-defense, you have to get up there and you have to admit that, yep, I killed this
Or I
person.
shot at the very least, right?
I shot, I killed, I stabbed, whatever you did, you have to admit that. And that's a hard pill for a lot of people to swallow because we want to get to the justification,
Right.
not we did it. It's this is why I did that. Well, what did you do? Well, I had to pull my gun because no, what did you do? And those words are very hard. And you saw Kyle Rittenhouse on the stand literally break down
Yeah.
once he started talking about what he did, not why he did it, but what he did.
Right. And we're going to talk a whole thing about his testimony on the stand, and I want to do a whole video on that whole thing, right? But I think that the big thing I want you to know here, want all of our viewers to know, is that in 95% of cases, if you want the self-defense instruction read to the jury, you must take the stand. So while it is a risk, there's a big payoff to that risk that you don't get otherwise.
Well, here's the thing. If he never took the stand, there definitely would have been a finding of guilt because there was no defense to what he did, if that makes any sense. So if you're claiming self-defense, be prepared to take the witness stand.
There you go. And so also we're talking here from when these actions happen to when the trial, you're talking 15 months. That's very typical, right? You and I are dealing with a trial, some charges coming up that is longer than that.
2 years.
Yeah, 2 years now, right?
Yep.
So that's not atypical. So we had this long, tried in the public opinion in the media long before it ever got tried in court. Yes, all the stuff with the prosecutor, all the stuff with the judge and the jury selection. I think because it got national attention, gosh, that kid's face is all over the national news forever. So it's not like he's going to be able to hide in a crowd very well.
Right. And here's the other part of this that you really got to understand. It's really the aftermath, like you said, the aftermath of all of this. That kid's going to need some help.
Oh,
Okay.
big time.
He's not. It's not like this trial was over on Thursday and Monday he's going to go out and get a job. Can you imagine the counseling that this guy's going to need? Can
Yeah.
you imagine, the help? Think about even trying to just get back in the flow of society at this point. If he hasn't been talking to someone or have the means to talk to someone, that's going to be very difficult as well.
Right. And I think that man, I think the other thing that I saw that I really liked here is which of his attorneys was it? Mark Richards who said, "Listen, we weren't trying to weren't arguing for a cause here. We were arguing for a client."
Yes.
And that I think is good attorney approach. He's like, "Look, we're not trying to score points for our society. We're trying to defend our client." And so you should expect a trial to go like this with all the circus that it entails.
Yeah, and he's absolutely right, because a true criminal defense attorney puts himself and other causes behind the client. It's all about the client, what's best for the client. Um, you don't care. You truly, when you are in that court, you care about two things. You care about the jury and you care about your client.
Right.
And anything other than that, and we were talking about the judge earlier, I don't care about the judge. I mean, you're going to fight me. We're going to do what we're going to do, and we'll respond respectfully back and forth. But this is a fight, and you are standing up for your client and that jury. Anybody else is a distant second or third in this world.
So, friends, remember here, if you are ever in a self-defense encounter, you're in a deadly force encounter in particular, you should expect this level of circus. You should expect to make the national news. Now, you might not. It might be okay. You might get a district attorney that looks at what you did and said, "That's clearly justified conduct. Here's a letter saying it's justified conduct. Thank you for cleaning up your communities. Let me shake your hand and have a fine day." But you should expect it to go this way instead, which is why what we said earlier, that only use deadly force if it's the only option on the table uh, to save your life or the life of somebody you love. And this is why. Next week, we're going to talk about Kyle Rittenhouse on the stand, the risk that was, and what we can learn from it. So, Terry, thanks so much for the discussion about how this trial went.
Thank you.